Hello, my friends. I guess I cannot call this conversation Can You Talk Real Quick, because we talked for almost an hour. I really didn't edit any part out of it. But Eric Segall is always a great guest. He's one of your favorites, and we covered a lot in our discussion today that I think you'll really love to hear. There was great stuff at the beginning, middle, and end of this conversation, especially at the end, by the way. We were talking about the future a bit and the Supreme Court and how it's affected our past, and I thought it was fascinating. I think he's always fascinating. Eric Segall, of course, constitutional law professor at Georgia State University, and you can follow him on all the social medias. Listen to his podcast, Supreme Myths. Get his book, Originalism as Faith and Supreme Myths. Of course, the OG. Some of you even bought it. All right, let's do it right now. It's time for the Legal Eagle. Eric Segall. There he goes. There he is. He's on the road. He's back home. He's all over the place, but he's here with us. Professor Eric Segall, thank you very much for gracing us with your presence in mind.
My pleasure, my friend. Before you start, I have a story. We'll talk about this in a minute, but I gave a talk at George Mason Law School yesterday. We're taping this on Wednesday. The talk was on Tuesday. I won't call it that law school by its real name. Its real name is offensive to me. So I'm calling it George Mason Law School.
That's the Scalia one, isn't it?
Yeah, I don't call it that. And after I finished, I got home last night. I got an email from a student. I'd like to read it, if you don't mind.
Interesting.
I meant a direct message on Twitter. I should have been prepared. I'll have it up in 1 second. Hold on. This is what he wrote. Hi, I'm a law student at George Mason University and just saw your debate. Thanks again for coming. I've listened and followed your work since you began appearing on Pete Dominic's radio show, pushing 9 to 10 years.
Oh, good. I'm trying to get to that demographic. If he's a law student, he must be in his 20s, maybe, right?
Yes.
Oh,
yes.
That's fantastic. I've got one.
I would like to tell your audience that this happens to me all the time. I'm not done. In fact, more times than not, when I give a talk to a big group of people, someone comes up to me and says, I've been listening to you since Pete Dominic. No one has ever come up to me and said, I've been listening to you since, period. It's always, I've been listening to you since Pete Dominic. So, thank you.
I have so many jokes I want to talk about and unpack that. I've been listening to you. I've become a timeline. I've become, in people's minds and people's lives. I mean, it is, I met a whole bunch of listeners last week in Pittsburgh. It was awesome, amazing people, and they kind of tell you when they started listening to the program, and then, what you and your work has meant to them. And it is I can't imagine anything feeling better. It reminds me of how my mom felt about being a public school teacher, I feel like.
Yes, no, it's I think it's incredibly rewarding for me because I get to inhabit two worlds, and that's what you've done for my career. My career next to you is just a scholar who gets invited to some scholarly things.
Well, I think, let me just ask.
I wasn't done.
Okay.
My scholarly hat, I've done that on my own, and I'm proud of it, and I get invited to highfalutin scholarly things sometimes. But my social media hat, my pundit hat, my public presence intellectual hat, I owe to you. That's a fact. Now you can say whatever you want to say.
Well, I appreciate that final kind and loving note.
It's true.
Now you can say whatever you want to say on your show where you talk about things. I think that it's really important. What I've tried to do is bring important issues to people in ways that they can understand them, digestible, understandable. I've only got an associate's degree, and I've learned so much hosting the show from so many people about so many issues. But it's one thing to learn it in law school. It's another thing to learn it on a radio program or podcast. You're able to teach both audiences in a way that I think makes you unique and special and real. And I think that I'd like to know what you think about the fact that most people don't understand the judicial branch and its role, much less the Supreme Court and all that it's impacted our lives. But I obviously love having you on because people love when you're here, no matter what we talk about. So, yeah, let's just say that. But also because I think the Supreme Court, the impact the Supreme Court, much less lower courts, which we could and do talk about, the impact they've had on our lives is as much as almost anything else that I can talk about with someone here.
It's interesting, Pete. There's a tweet
and
yesterday.
People walk around not knowing how much the Supreme Court has affected their lives. My daughters, they walk around in space not knowing all of these things, most of these things about their own bodies.
I mean, if you think about it, most of the large social, cultural issues we've been fighting about for the last 30 years The Supreme Court has had the final word on it. So same-sex marriage wasn't legal in most places, and then it was. That's a good thing. That's the only good. That's one of the few good things the Roberts Court did. But that was a country-changing event, right? Now, thank God, gays and lesbians can get married. But if you think about what they did to Obamacare, how they this is not a politically correct word in a different context, but I think it is here. He crippled the law by taking the Medicaid part out of it. That was a major event for the American people. The court upholding the law was a major event, but actually the Medicaid thing was really serious, and that really affected us. Affirmative action. Now, thousands of colleges and universities across the country are scrambling and trying to figure out how to do admissions in the face of a Supreme Court opinion that is incoherent when it comes to it, because the opinion says you can't use race, but students are allowed to write essays about race, and you're allowed to read them. And I don't know what that means. If we can't use them, why are we reading it? Abortion is self-explanatory. And then there are things that most Americans not involved in politics and law don't think about. But Pete, the Roberts Court has made a lot of changes in administrative law that are really important and whose effects we won't see immediately, but we'll see down the road. And that affects all Americans.
Talk to me about what, just again, therein lies where maybe sometimes my skill, I don't know, I need to explain administrative law and what cases and how they actually have an effect on our lives.
And there's a part of me that wants to spend this whole conversation about it because it is actually super important.
Well, I want to skip around to a few subjects. I don't know how much time you have, so let's just construct it in that way that we hit these few things that But
well, this one is
there's no need to shrug. There's no need to shrug at me like that. I don't think.
Did I shrug?
You did.
I didn't mean to shrug. I think I had an itch.
Oh, forgive me for attacking you.
There are three cases this term. I don't want to talk about those cases, but there are three cases this term that raise that issue. What is going on here is after the Great Depression, the president, FDR, and the Congress enlarged the federal government tremendously. Now, there was a lot of federal government before that, but the New Deal, of course, added a whole bunch of agencies, a whole bunch of laws, and the Supreme Court, after initially striking down two of them, upheld all of it after FDR threatened to pack the court, and then the old geezers died, and he appointed a bunch of other people. And we've been living in that administrative state ever since. The Roberts Court wants to cut that back. And what cutting back the administrative state means is Congress is not allowed to delegate to the president as much as Congress wants to delegate to the president. In a country that is 50 states and 3,000 miles plus Alaska, Hawaii, Guam, and Puerto Rico, Congress can't legislate with specificity on the big issues we needed to legislate because they can't do it. They don't have time, they don't have the resources, and the country's too big. It's not 13 colonies on the East Coast. So what Congress does is it has goals. Let's make air pollution better. Let's cure this. Let's give money to schools, whatever it is. And then they send that law to the president, the executive branch, who has the resources and the people to implement the laws. Because our court today is libertarian more than conservative. It's more libertarian than it is conservative. It is conservative, but it's more libertarian. They don't want the federal government passing these laws, period. So if they get in the way of Congress delegating to the president, which is what they're doing with the major questions doctrine and a bunch of other cases, if they stop Congress from being able to delegate to the president the way Congress wants, it's not that Congress will do it itself. It's that, Pete, Congress won't do it at all.
And the president would then have all the power and this whole federalist idea.
No. That wasn't my point. Sorry, Pete. No, you missed my point.
Sorry.
If the court keeps on this paradigm and keeps cutting back Congress's power to delegate to the executive branch, what they're saying is, Congress, you pass the law yourself. But Congress can't do that. So what they're really doing is cutting off the legs of the federal government and going back to a pre-New Deal idea of federalism. That's the problem. It's serious, and it's going to haunt us for years.
So
did that make sense? Was that accessible?
Yes, it does. I'm just trying to think of just one follow-up question, how to word it, which is, when you say that the president, Congress passes a law, they give it to the president, he signs it, and then the president carries it out. I think what you mean there is that the federal government has the Department of Transportation, the Department of Commerce, the Department of Agriculture. In each one of those departments, there are hundreds of thousands, possibly more people working, the Department of Defense, and they all get their directives to some extent from the executive branch through the laws that are passed. But the executive branch then takes that law, pass, and says, this is what you got to do now. Gay people can be married in the military. Although that was that openly serve the military. I just picked one. There's a million examples. I could have picked a billion, and that's what I picked.
Can I give a really fun one, a really good one?
Sure.
So when I think I told this story on your show 10 years ago. So we're going to assume it's okay to tell it again. When I was at the Department of Justice working as a trial lawyer, and I litigated cases from people suing agencies. One day I was called into the big boss's office, along with another person in DOJ who was very conservative. And so Congress in 1989 or 88 passed a law saying the National Endowment for the Arts, which is a really important federal agency, Pete. If one believes culture is important to society's well-being, and I think you and I agree that culture, movies, museums, art is important to any thriving culture, this is the federal government's way of giving money to artists who can't afford, do stuff themselves. Anyway, so there's a lot of money at stake. And then Southern senators got involved and said that you're funding obscene art that is obscene, and the federal government shouldn't fund obscene art. So the law was from now on, the National Endowment for the Arts is prohibited from funding obscene art. And then it said the executive branch will define what obscene means. It was my job and this other guy's job, another law professor now, back then a trial lawyer like me, to pass. Pete, we sat down on a piece of paper. We wrote words. We wrote words on a piece of paper. And 3 months later, they were law. Actual law. No one voted for me. No one knows who I am. Now, is this law that important? Not really. I mean, who cares? But that's how it works. What just happened, we're not going to fund obscenity. Executive branch figure it out. It's how our country works. We don't want air pollution. Executive branch figure it out. We don't want the highways have to be a certain speed. President, figure it out, and so on and so forth. Now, what conservatives and Federalist Society members would say to you is this all started in 1937. It's not part of the original meaning of the Constitution, and we have to cut it all back because it violates separation of powers. And I'm here to tell you that is wrong on every level. The original Congress, the very first Congress, gave the president all kinds of instructions and discretion, and that's been going on ever since. So it's a stupid. They're masking a political objection to the big federal government. They're masking that with resort to original meaning in text, and they're just wrong. And eventually this will correct itself, but it's going to take years. So in sum, what Supreme Court is doing is making it harder for the federal government to pass laws. Why? Not because of anything in the Constitution, but because they're libertarians.
Okay, well.
Scary stuff. Good morning.
No, it's important stuff. It's important stuff. This is what we're talking about. We want to understand how things work here, and that's why I love talking to you about the Supreme Court, in that case, how laws that are passed are carried out. It's really fascinating, and I think it's important. I'm saying that's what people really need to understand. Instead, we get in these ridiculous arguments about things that aren't happening too often.
Right. Aren't happening. Worse, ridiculous arguments about what people meant in 1789 in a completely different world, in a completely different government, in a completely different environment. But this issue, Pete, is something I think non-lawyers, non-law professors can really appreciate. Who gets to make law in this country? Well, the Constitution does say Congress. Congress passes the laws and the president executes the laws. But that format, and the court interprets the law. None of that's true, of course. The Supreme Court makes law all the time. And the Congress they just can't do it, Pete. Think about it. When we began, we had 13 states on the East Coast. Now we have 50 states across 3,000 miles, Alaska, Hawaii, Guam, Puerto Rico. They're going to tell you, the Federalist Society people who don't like this system are going to tell you that the president has taken a law-making function in violation of the Constitution. We have no choice. Just forget law. As a pragmatic, reasonable thing, Congress can't do it. The president has to. We should be having, and that's where the debate should be. The debate should not be what the Congress of 1789 thought. And that's my final word on this subject. You want to talk about guns for a second?
Yes. You were just here at, was it Fordham?
I've been there twice. One was Hofstra, one was Fordham.
You were talking guns as it relates to the Constitution, I imagine, but it was a larger than that issue, apparently because there were a lot of public health people there. And I really want to get your perspective. I should be talking to more of those people, by the way, right here. I mean, we talk with Aaron about these issues, but haven't really. I mean, what did you hear?
Right.
Where were you? What happened? And what did these public health people express to you about gun violence?
This was a conference jointly sponsored by Fordham Urban Law Review and Johns Hopkins, something. Johns Hopkins being a graduate school. And so it was a day-and-a-half conference, and at least two panels were really devoted more to public health than to constitutional laws about guns. I was there to talk constitutional law about guns, but the public health people were there to talk about the risk that guns pose Americans. And it was fascinating. And there were charts and diagrams. It's more dire than you think. And the reason this is all coming up now is because the Supreme Court granted cert, going to hear a case out of the Fifth Circuit Court of Appeals, which we should rename the Fifth Circuit Court of Insanity, and where they held that the federal law that says if you're under a domestic relations protective order, meaning you can't go within 100 feet or 50 feet or whatever of somebody else, then you're not allowed to own a gun. Somebody was under a protective order, owned a gun, sued, and the Fifth Circuit struck that law down as unconstitutional for the very compelling reason that in 1791, no one thought domestic violence was so bad, so we can't take away your guns today because of domestic violence, which is, of course, the stupidest argument in the history of time. What these people said at Fordham was the correlation, and I just data everywhere. That's why they were there. They provided the data. There's a huge problem with guns and domestic violence specifically. But forget suicides, forget
ahead. Yeah.
You know, and it's not just the statistic is not just how many women or men are hurt in domestic violence situations by guns. One of the very smart Johns Hopkins professors gave us data on that, and it was pretty compelling. But then she said, and it was fascinating, she said, but here's what we can't measure. And it happens every hour in this country. Every hour. Someone picks up a gun, usually a man, not always, sometimes a woman, but usually a man, and points at their spouse and goes, I'm going to fucking kill you. And then doesn't. But the presence of that gun changes everything about the dynamic.
Sure.
Everything.
Sure.
And men, in fact, and she told great stories about real cases where men would reach for the gun, without really intending to shoot it. So we're not saying this guy was going to kill his wife, but he was definitely using it as a method of coercion. And that's a serious thing. Like, that's not, 400 million guns. A lot of them are being used to do exactly that. So that was fascinating. One of the most interesting things of all for me was afterwards, a whole bunch of the public health people came up to me. And I was, by the way, I was the last speaker, the very last speaker after a day and a half. And the crowd was sleepy, to say the least. So I had to be like Eric on steroids to wake them up, which I kind of did. Not Eric on steroids, Eric on hyper drugs or something, whatever. Anyway, so I was very loud and very boisterous about how awful Bruen is as a constitutional matter. Bruen is the case from that did all this. Anyway, the public health people came up to me, Pete, after the class, and they were like, we had no idea the case was that bad. We knew it was a terrible thing for us in terms of public policy and health, but we had no idea how little legal substance the decision actually has. And we're really glad you told us this because it gives us a different perspective. Because we kind of thought, in a way, the decision kind of follows from Heller and it's just business as usual. It's not. That's not true. It's not business as usual. And they were very appreciative of the legal perspective. And I learned so much from the public health perspective. And then the last comment is we all agreed we need to do this much more often. Bring in interdisciplinary experts, as you do on your show, bring in experts to go along with the lawyers, because now I have stronger arguments to make when I make my legal arguments. Well, go ahead.
Yeah. For example, I mean, I'm not quite seeing where the overlap there is or how you need each other. The better they understand the law, the better it is for everybody for a lot of different reasons. But the better you understand, the violence and what it does and to communities, much less people's bodies, what does that do for you, the law scholar?
So although Justice Thomas in Bruen wrote for the majority, saying that from now on, when somebody challenges a gun law, anybody challenges a gun law, any gun law, there's only one question. Can you find a similar law in 1791 or 1868? That's why the Fifth Circuit struck down the federal law, because they said back in 1791, people weren't disarmed for protective orders and things like that. It's the stupidest, dumbest thing ever. The fact there wasn't a law about something doesn't mean society wasn't concerned about it, or doesn't mean society can't act on it. In addition, judges are not historians and are terrible at it. And that finally, Thomas also said in that opinion, now, we're not saying you have to find an exact same law. You have to find a law that's comparable or similar and then compare it. Well, now you've opened up discretion, because once you say that, so what's going to happen, what has happened in the lower courts for the last 2 weeks since that case came out, is Trump judges and Republican judges have struck down laws. Liberal judges have not. 88% of the laws that have been struck down were struck down by Republican judges, and 50% of those were struck down by Trump judges specifically. So this has been a sea change caused by a political change in the court. Public health people like hearing that because it gives them hope. All we have to do is change the court again. Not all, obviously, but and my talk was mostly about how Bruen is not going to. This case is going to go away. I may not be alive to see it, but it's going to go away, just like Roe. Pete, I've been saying on your show for 30 years. For 10 years. Roe will at some point go away, and it did. At some point, Bruen's going to go away. It's not sustainable because the legal reasoning is so incredibly terrible. And so saying that to the public health people got them energized in a way. And most of them were in their 30s and 40s. They're going to be around a long time, as opposed to me, who's not going to be around much longer. And I gave them hope that this whole thing might change, because I want to be clear about this. The most important point I just made in the whole 10 minutes of monologue was public health people are really worried about this.
Well, they should. I thought that's the thing I thought you were going to say, because it's the craziest statistic, and the leading cause of death for adolescents in America of a certain age, more likely boys, I think it is gun violence.
That changed 3 years ago. That wasn't true until 3 years ago. Right, it was car
accidents or something?
Yeah. Pete, and actually, I don't have the exact number in front of me, but the percentage of black teenagers who die via guns, as opposed to all deaths, is like 50%. It's way up there.
And I bet the percentage of white teenagers who die of suicide is way up there.
Yes. So what's unbelievable is that the CDC has always thought that guns are a public health problem, but every time a Republican president comes in, they forbid the CDC from investigating it as a public health problem. So what these Johns Hopkins people are doing, of course, people don't know, Johns Hopkins is the most prestigious public health, I think, institution in the country. They are taking it among themselves to do all the research. And of course, with Biden in office, the CDC, I think, looking at guns. But what they were saying was, we can have larger debates, but just on the case that's in front of the Supreme Court this term, if someone is under a domestic relations protective order, should they have a gun? The answer is obviously not. The answer is just obviously incredibly not. But the court in Bruen said you can't argue that way. That's not an argument that can be made. The only argument you're allowed to make is, was there a law like this in 1791? And that legal, or 1868, when the 14th Amendment got the Second Amendment applied to the states. And Pete, it's just such a backwards way of looking at things that it's not sustainable. The more real data we can bring to not just the court. So my argument was, what the right did to Roe and what the right did to Casey, but really Roe, the left needs to do to Bruen. Bruen is Roe versus Wade for guns. It's what it is. Except that the goal is terrible as opposed to Roe versus Wade, which the goal, I think, was admirable.
Remind people what Bruen decided.
New York said that if you want to openly carry a gun, you have to get a special license. And we're not going to give special licenses out unless you have a very specific need, like you were mugged twice, in the last 2 months. Now, there's so much misinformation about this, because when that case was briefed 2 years ago, a lot of conservatives and gun folks and the NRA and all those people said only like 6 states have this kind of law, maybe it was 8. 8 states had this kind of law. So so those are outlier states. And that's a reason why it's unconstitutional. But the 8 states that had those laws were California, New York, and a bunch of other high populated states, which accounted for a huge percentage of the population. That argument was stupid. I mean, it was a dumb argument. And the court said New York couldn't do this. This law had been in the books, Pete, since 1911. 1911. That's how old this law was. And the court struck it down because it said there wasn't laws like this in 1791, to which I responded, and many people responded, New York today, Times Square today has more people in it than the entire state of New York did in 1911. I mean, it's what we're doing here is protecting Manhattan, mostly. Buffalo, Albany, maybe a little, but mostly it's about Manhattan. And Manhattan didn't exist the way it does today in 1791. Right. They had no reason to worry about it. 12 million people in a,
and there's just so much data on. And I've talked to Cy Vance, the former Manhattan DA at the Aspen Ideas Fest, and we talked about this before it was ever, well, I guess it was always something being challenged. But he talked about the fact that violence is so, they're able to keep it so down in New York because of these laws about weapons. You can't even have like a switchblade on a subway in New York City up until this decision. Yeah. So, I mean, like policy, and it doesn't take a lot of, you have to be a genius to understand that. But go ahead.
There's also something, a backstory that I think I can make entertaining for your audience. So when Heller came out in 2008, and Heller is the first federal law case in American. It's the first Supreme Court case ever to recognize a private right to own guns. Before that, it was always a militia right. So Heller was the case that changed all of that. When that case came down, there was a weird paragraph in it. That's a good paragraph that said, everything we say today, of course, doesn't suggest that laws that restrict guns in sensitive places, laws that restrict who can own guns, laws that prohibit felons from owning guns, all these disclaimers for traditional gun laws, which is why from 2008 to 2022, very few gun laws were actually struck down. Like a huge percentage of laws were upheld based on that paragraph. Then we learned through Joan Biscopic's reporting that Justice Kennedy's fifth vote, and it was always the fifth vote in those days, Justice Kennedy's fifth vote in Heller was conditioned on Scalia putting that paragraph in.
So important. That reporting is so important, and I think one of the more fascinating things about talking to you about these things
it's really that's how they work. Scalia, that's how the Supreme Court works. The majority opinion will be written by who's ever writing it, and then they'll get memos from the other justices. I agree with this. I agree with that. But can you take out footnote 6, or can you add 3 lines to page 10? They negotiate it, and the opinion comes out. In this case, if you believe Joan Biscopic, and I do because she's a great reporter, I've had her on my podcast. She was very good. She reported, and I think she's right, we kind of knew this anyway, that Kennedy insisted that paragraph be in. Pete, you and I used to talk about, why is the Supreme Court not taking new gun cases? After Heller and then this other case in 2010, the court didn't take another gun case for 12 years. And we talked about that a lot. And what I said to you at the time was because no one knows how Kennedy is going to vote. And now we know why they didn't know how Kennedy was going to vote. Because of that paragraph, which he insisted that Scalia put in. Here's the big deal about Bruin. Once the court goes 6-3 instead of 5-4, and now Kennedy is gone and all that stuff, that paragraph in Heller, some lower courts are saying now doesn't survive the Bruin decision. So we're now going to litigate which sensitive places states are free to prohibit guns. We're going to litigate who is a felon for purposes of being disarmed. All things Justice Kennedy made Scalia say, states can do all of that. That's now been wiped away. And that's the problem. And that right there is the problem. So it's going to be interesting to see what happens. I think this domestic, can you imagine a New York Times headline that says this? Supreme Court affirms the invalidation of domestic relations law that prohibited people from owning guns. I didn't say that right. If you're under a protective order, you are not allowed to be disarmed. Can you imagine a headline like that, Pete? Like that's insane, right? Wouldn't that be insane? I mean, if you're under, so the smartest person I know who's defended,
you're not allowed to not have a gun. You have to have a gun.
Pete, if you're subject to a domestic relations protective order, meaning the government has told you can't go within X number of feet of a spouse, a child, a friend, whatever, an enemy, whatever, then you're not allowed to own a gun.
Oh, I'm sorry. I misunderstood that.
And that's obviously the right answer, right?
Yes.
That's obviously the right answer.
The headline you read was what misled me.
So if the Supreme Court...
I'm blaming.
What I'm saying is, this case from Texas, this case from the Fifth Circuit, which says that law is unconstitutional. If the court affirms that holding, the headline is going to be, people subject to domestic relations protective orders can own guns.
Right.
And that's an insane headline.
Right, got it.
Now let me give you the strongest argument on the other side, just to be fair to everybody.
Okay.
We
appreciate that.
Especially to be fair to Clark Nelly, who's a friend of yours, who you and I have had on your show.
Yeah. He's a Cato guy, very pro-gun. Clark,
he is, but he's thoughtful and he's not a nut. He's a smart guy. I like him. We disagree about a lot of things, Pete. He's a solid, thoughtful person, which is why he's been on your show several times. And this is what Clark says. The opening line of his brief, he works for Cato. Basically the first paragraph says, of course, dangerous people can be disarmed. See, right there, it's reasonable, right? Of course, dangerous people can be disarmed. This case is not about, he's claiming this case is not about that. This case is about what procedures do you have to put in place to determine the person is dangerous. He would agree a violent felony conviction, if you're guilty of a violent felony, Clark is going to say you can be disarmed. And that's why he's thoughtful, because the NRA wouldn't say that, but he would. But what he's saying about this case is nationally, these protective orders, these domestic relations protective orders, are given out fairly freely, because if you're a judge and someone comes up to you and says, my husband's thinking is my ex-husband or my ex-boyfriend, stalking me, the judge is going to issue the protective order, right? I mean, just to be safe. So he's saying the procedures aren't good enough to strip somebody of their constitutional right. With the right procedures, then this law would be okay.
Hey, listen, I got mad at my wife. I said I was going to kill her. That should not be enough for the government coming and taking my pistol, because I need what if during the time period that my pistol is removed from me for threatening to kill my wife or whatever it is, then that's when someone comes in to rob my home and I don't have my ability to protect myself. I mean, it's such a tortured argument in my mind, but it's got to be something along those lines, I'm guessing. I should probably ask Clark.
Well, if Clark heard you say that argument is tortured, he and I have debated so many times that I know, and again, I really like him. I know what he would say. He would say, the reason, Pete, you and I agree that it's a tortured argument is because we don't view the right to own guns really as a real right. Like if this were free speech, if we said you can't talk about politics unless X would have to be unbelievably compelling.
Listen, no, hold on a second, though. I mean, if I conceded that owning a gun was a right, I would then still say, but there are a whole bunch of stipulations and regulations around that. Yeah. And you should have to jump through a million hoops to get a gun, be able to keep a gun, understand a gun. And there should be, and I would have all the laws that the anti-gun violence, quote, / gun control, groups wanted to pass. Like I would be.
No, Pete, that's a fine response. And what Clark would say is, whether you know it or not, that response is a reflection on how important you think the right is. Because if I said to you, when do we get to tell somebody they can't talk about political speech, criticizing the government, you would say almost never. There's almost no situation where the government can tell somebody you can't talk. In the world of Clark Nelly, unfortunately, in the world of Heller and Bruin, to say somebody you can't own a gun. In fact, Justice Thomas went out of his way in his horrific, illogical, irrational, incomprehensibly bad opinion in Bruin. He went out of his way to compare the Second Amendment to the First Amendment. And he said, what we tolerate in the Second Amendment, we would never tolerate in the First Amendment. So Clark would say, and he'd be right, if you and I equated gun rights with the First Amendment, we'd feel the same way. But you and I don't do that because that's stupid. I would say to Clark, that's stupid. Yeah. Democracies can thrive without guns. Democracies can't exist without speech.
Well said. And I really appreciate the way that you are doing your best to present Clark's arguments. I do. I mean, I'm being honest. I know listeners do as well. And we should have him back on to talk about all that at some point, maybe. But when you going back to the point of the public health issue, there's just no other threat that we wouldn't regulate. I mean, if it were pools, we put fences around them. Lead. I mean, there's so many things that have killed us over the years, and there's so many laws that we put into effect. They have a rumble strip right down the middle of the road in Vermont. The whole freaking road. There's a rumble strip.
And somebody went to see their daughter in college.
It's amazing because if you go just near the center line, you're like, oh, too close. That way you won't have a head-on. It has to do with texting. It's a brilliant idea because it saves lives. Because there's nothing in the Constitution, however, about roads and safety, or pools and safety, or drinking water.
And it has always been my perspective, and it was the perspective of every justice ever into 2008 or so.
Right.
That there is no constitutional right of a private person to own a gun.
That's always been my favorite point to make when people didn't know about that. Did you know up until 2008 that no one was arguing in the Supreme Court? And
your ex-friend and my ex-friend Keith Kaplan, who hounds me on Twitter sometimes,
oh God,
and others respond to that argument.
He was a listener. I would never call him really a friend,
yeah,
but
fair enough. He's an okay.
Thorn in my side, but
you're a nice guy to listen.
Yeah, I hope he's doing well. Go ahead.
That I think what Keith would say is there weren't federal laws regulating guns until fairly recently.
Okay,
and that's why there are no decisions. But he'd be wrong if he said that.
Yeah.
The other thing is he would cite a lot of state cases, but those state cases involve state constitutional provisions protecting gun rights, and that's the last point, Pete. Before I think we should move on. 41, 2 or 3 states, depending how you count, have provisions in their constitution protecting gun rights. We don't need the federal government to do this. The states protect their own gun rights, which means the state of Georgia can only pass certain laws about guns because the state constitution has a gun provision. So the only issue is what happens when Congress passes laws. Now this term is about a federal law, but 99% of these cases arise under state law. For the Supreme Court to tell states, you're not allowed to pass gun laws, when those states have provisions in their own constitutions protecting guns, saying the Second Amendment is stronger than your state constitutions, is historically bizarre, not what was the purpose of the Second Amendment, and is incredibly stupid. So we really need to get to a world where Heller and Bruen are gone, or at least mostly gone. We will get there, I'm sure of it, but it's going to take 10, 20, or 30 years.
Right.
And the same tactics the right used for Roe, the left needs to use for Bruen. And one of those tactics is, in every case, give the judges the originalist argument because that's what they want, but in footnotes, parentheticals, asides, criticize the text and say we can't make 2023 decisions on guns based on 1791. Nothing is dumber than that. And keep saying that over and over, which is what they did with Roe versus Wade. So eventually we'll reverse it.
Well, I do have a silver lining for you. I'm glad.
I was going to say a silver bullet. I was like, wait, what?
I'm glad you think it's going to work, in the next 20 or 30 years, because, it's going to take a lot of new judges, I guess, on the Supreme Court. And I'm glad that you think in 2070 that this is still going to be such a huge issue, gun violence, as opposed to the robots. Like, that to me is really a positive, I think, outlook. So I appreciate that.
If America makes it to 2070, I think we're ahead of the game.
Yeah, I agree. We're right there.
Trump for a minute?
We're on the razor's edge. Go ahead. Now, how much more time do you have, and what do you want to do with it?
Well, I have 15, 20 more minutes, but are we going to bore your audience if I go on 15, 20 more minutes?
I mean, go ahead. I don't have to be anywhere, and people can always press stop.
Right. Okay. So in the next
some of them can't. Some of them are a little bit OCD. Like, I have to listen to the whole thing. I wish it wasn't so boring. Why do you do this to me? No, nobody says that. I edit some things out. Go ahead.
Okay. So in the next 2 weeks, 2.5 weeks, I'm going to Stanford and then the University of Minnesota to talk about whether Donald J. Trump should be disqualified from seeking the presidency in 2024 because Section 3 of the 14th Amendment says that if you engage in a rebellion or insurrection against the United States, then you can't hold office if you are a person who had taken an oath to uphold the Constitution, meaning if you're a government official. If you work for a local, state, or federal government and engage in an insurrection or rebellion, you're not allowed to hold public office again unless Congress, by 2/3 vote in each house, takes away the status of being an insurrectionist. Now, about a month ago, 2 FedSoc All-Stars, 2 conservative originalist Hall of Famers, one of whom, by the way, ironically, Pete, this is an amazing coincidence, one of whom is the guy I wrote a law with at the Department of Justice about obscenity. So it's coming full circle here. One of these 2 people is the same guy I was telling you about earlier, who I wrote a law with. Anyway, their position on every issue is Trump is disqualified now, that January 6th was an insurrection, that the 14th Amendment, Section 3 applies to the presidency, and that what should happen is state officials should disqualify him, then he can challenge that in court. Court should uphold the disqualification, and he should no longer be allowed to run for the presidency. Now, after they did that, the law professor machine went into full throttle, and a bunch of other originalists and historians, law professors, started weighing in. And Pete, I'm not making this up. As we sit here taping this, there are really smart originalists and really smart historians who disagree on every issue involving Section 3. Does it apply to the presidency? Some say yes, some say no. Does it apply beyond the Civil War? Some say yes, because that's why it was passed with the Civil War. Some say yes, some say no. Was January 6th an insurrection in terms of Donald Trump? Some say yes, some say no, as an historical matter. So what my job in Stanford and my job at Minnesota, the reason I've been invited to go to both things, is to say that's the wrong way of looking at this. I don't care what happened in 1868 or 1869. I don't care about that history. This is too important an issue. We're talking about disqualifying from running for president a former president who also is the front runner for one of the two major political parties. If we're going to disqualify that person, we better be very sure we're right. Constitutionally, we can't be sure because we don't know what they would, the history and text and it all, it's just too imprecise. So my contribution is, under today's politics, what should we do? How does America get through this? What's the best answer today? That's my question.
It's weird. So you're making a political argument at a legal conference.
What I'm saying is Section 3 of the 14th Amendment is imprecise enough and vague enough where we don't really know what it means as an historical matter. And the proof of that is really smart people disagree on every point, and they're really smart people.
Yeah.
So my answer is I don't care. I don't give a fuck.
Yeah.
Let's talk, because we can do it. Pete, the president has to be 35. That's what the Constitution says. I'm not going to get into debates with people about whether the president has to be 35. The president has to be fucking 35. The Constitution says that. Inauguration Day is January 20th. We're not going to debate when Inauguration Day is. It's January 20th. But what insurrection means, whether or not the presidency is an office of the United States for the definition of that provision, whether or not it applies beyond the Civil War, all these things are open questions.
Right.
Because they're open questions, we should do what's best. And I have reluctantly come to the conclusion that what's best is absolutely not to disqualify Donald.
Do not disqualify him for this. It's a really interesting thing to watch unfold because of those who are arguing it and what their arguments are. But I think you just laid it out really well in terms of the three different kind of components or different issues that are hard to determine whether or not it's an insurrection, and the other two that you mentioned.
Well, the people who so Lawrence Lessig of Harvard Law School.
Yeah, I saw you writing. Go ahead.
And Lawrence Lessig he'd be your best friend because he's all about election reform.
Yeah, no, he used to come on the show back in the day. Yeah. Dude walked all the way across New Hampshire, ran for president.
Yeah, he also lived around the corner from my parents, and my mom once ran into him when she was alive. And he claimed to have known me. I don't think he does.
Oh, that's awesome. Yeah. Well, go ahead. He's a smart cat.
Very smart cat. A little bit crazy, but smart.
He's got a little bit on the craze, but I like him. I like him. Yeah, go ahead.
And he did a blog post the other day, or an article saying, as a practical matter, if Trump is disqualified, now we have to talk about Ted Cruz. Now we have to talk about all the members of Congress who voted not to certify the election results. Now we have to talk about Pennsylvania and Georgia and all those people. And then he said, are we really going to go down that road? We're not. The answer is we're not going to go down that road. That'd be a silly road to go down. Now, I think for the people who committed violence or trespassed on January 6th, they're insurrectionists. Very few of them held government office, but for those who did, they should be disqualified.
Yeah, the question, right? The question is whether or not
main argument about Trump, Pete, and then
the question there, though, is whether or not they are qualified to run for office, for president, for congressman. And what you're saying is these insurrectionists who attacked on Capitol 6, clearly they're not qualified to run for office. Although it's funny because
Pete, hold on, only if they held office before, because it only applies to people who take oaths. Yeah.
I'm glad you said that, because that guy that was running for governor in Michigan, in the Michigan, I think, Republican primary, I don't think he was a nominee. He just got sentenced to 60 days for breaking into
New Mexico state courts did disqualify someone under this provision. One person since 1869, one person has been disqualified, and it was in New Mexico last year. But here's what I want to say, Pete. The goal, I think, for Americans who are sane is how do we get rid of Trumpism? And notice the way I phrased that. I didn't say get rid of Trump. I said get rid of Trumpism, because you've discussed on your show, I have heard many people talk about the differences between, those are two different things. One is the man, one is the movement. If we disqualify Trump and his voters don't get to vote for him, based on what they're going to say is a legal technicality, then Trumpism, I think, will get much worse. Now, 3 years ago, I might not have said that because Trump's oratory skills were so, I hate to say this, but so great for his base that nothing would have. But I think now he is clearly deteriorating. His speeches are more rambling. His audiences are much smaller. He's not the same person. And we need to get rid of him. But more, I mean, we need to make him not be president again. But we have to vote him out, Pete. We have to make that decision in the voting.
You think the argument needs to come? I agree with that. I fully agree with that. Who knows if he's going to be the nominee, if he's going to live that long.
Yesterday, a very thoughtful FedSoc person and I were debating something else. And then afterwards at George Mason Law School, we were talking about this issue. I will say he gave me an argument that made me pause. Because this is not easy. I don't think what to do here is easy. I think it's hard. His argument was most social movements require a strong leader. He's the strong leader. Remove the head, and the social movement dies away.
Well,
and that's not frivolous. That's a reasonable position. History says that could be true.
Yeah.
But I don't think that applies to this moment in time so much. So that's why I don't agree. But it's a reasonable argument.
Yeah, it is. I don't think it applies to this moment in time that much either. But, well, let me just say real quick. I don't know if you heard about this, but this guy, the Young Turks guy, Cenk Uygur, announced that he's going to run for president. But he wasn't born in America, but he says that doesn't matter.
Was he born to American parents?
Yeah, I think so.
I believe. Okay, I have not researched this issue, so I'm talking off the cuff here. But I believe if you're born to American parents abroad, you're a natural born citizen. Pretty sure. Wasn't Ted Cruz born in Canada to American parents? I think he was. Ted Cruz, I believe he was born in Canada to American parents.
This guy was born in Turkey and became a naturalized citizen.
Ooh. No, then he probably can't run.
That's such a gross stunt.
It is. It's horrible. It's stupid.
He ran for Congress and got nothing in California. And
I don't think I was born in Canada. I was naturalized here in 1983. I am not eligible to be president of the United States. Much to everybody's happiness. I am not.
I was going to say we would vote for you. All right. Anything else? One more thing.
I just want to alert everybody that this gun case, which is going to be argued in the fall. Next, I think in December, I'm not sure when exactly, but whenever it's argued, I want people to step away from the law for a minute. If some judge decides, I don't even care how much evidence there is, that there is a reasonable basis for a domestic relations protective order, based on the data that I heard at the thing I was just at, what the role of guns in domestic violence is a really scary thing. And this case is completely, Pete, if we can't pretend, and let's be honest about this. Of course, there's women on men violence, of course. But mostly, this is men on women, male on female violence. And if we can't protect the women in our country this way, I don't know what to do. It's just... Well,
we can't. We can't even protect their healthcare rights. So clearly, we can't. I think the answer is we can't.
This law should be upheld.
We have to try, but we have to try. We all have to try.
Yeah.
But currently we are failing on the issue of gun violence and women's reproductive rights. But that doesn't mean, as you have said many times, that we ever stop trying. And just on the gun issue, I do think, we should always mention a lot of laws have been passed at the state level. You'll tell me, I'm sure they'll be challenged at the Supreme Court, but many of them, the point is they're saving lives right now with many of these laws, and more people are being convinced, I think, about it. So on all these issues, but
I just want to make two final points.
Yeah,
I don't want to give the audience the wrong impression. A lot of gun laws, most gun laws, have been upheld.
There you go.
But really important ones have not. So that's a big deal. And the second thing I want to say is, going back to the conversation you and I have been having now for 12 years, the only reason the only reason we are in this position regarding guns, affirmative action, abortion, and a ton of other issues is because Mitch McConnell would not let Garland get his seat and then rushed Amy Coney Barrett in the very last minute. Those political decisions is the reason we have the Supreme Court.
Yes. No, I'm so happy you go back to it.
And Peter, I'm not even going to criticize. I could, but I'm not going to criticize McConnell for breaking. Under the Constitution, he's allowed to do what he did. It's a bad idea. It breaks norms. It's not unconstitutional. And the point I want to make about that is to have a Supreme Court that is staffed by people based on death, retirement, and political calculation is absolutely the worst way to have a Supreme Court. And we just need fixed terms. We need 18-year terms. We just do, because this is insane. Our entire country has changed because McConnell was able to do those two stunts.
No doubt about it. I mean, you could point to other inflection points throughout time. You could look at the 2000.
Look at 1991 when Justice Thomas replaced Thurgood Marshall. Yeah, that changed everything, and Bush lost. So
I wonder what our alternate timeline is like. I wonder how different it is. It's like so similar, except for a few of these decisions.
No. Let me address that. If Thurgood Marshall wait 6 more months in 1991 before retiring, he didn't think Bill Clinton could win. No one thought Bill Clinton could win at the beginning, and the advice he got was Bill Clinton's not going to win. So he was very sick, so he retired. His retirement, replaced by Thomas, has given us. There's no Heller without that. Heller doesn't exist. Right. We're not even having this conversation if that happens.
It would have been Clinton. It would have been Clinton's seat to a point.
Yes,
if he could have held on.
And a lot of and dramatic.
So you blame Thurgood Marshall for all of our problems now.
I do not.
You blame both Ruth Bader Ginsburg and a black man and a woman. No. You blamed for their health.
I blame the advisors of Thurgood Marshall.
Sure.
Who didn't say to him, "Wait for the election."
Sure. Yeah, no, that's a very fascinating alternate timeline.
One last thing. Now that you triggered it, the notion that we traded Thurgood Marshall, the most effective civil rights litigator in American history, who in fact argued Brown versus Board, replaced him with Clarence Thomas, the worst justice maybe in American history, and who stands for exactly the opposite of what everything Thurgood Marshall stood for. And then Ruth Bader Ginsburg, the most important gender rights litigator in American history by far, is replaced by Amy Coney Barrett, who has the opposite values as Ruth Bader Ginsburg, is almost too much to bear.
It's almost too much to bear is the title of your memoir on the court.
You got it. That's my third and last book. Too Much to Bear. Yes, that's a good title. I've been looking for it. That's it. That's the one.
Nope. It's got to be a little bit more optimistic. Almost too much to bear.
That's what I say. I said almost.
I know. We appreciate you. All right, bud. Thank you. Awesome as always. I got to go post this for everybody else to listen to now.
Thanks, Pete. Take care.
All right. Another wide-ranging, great conversation with Eric Segall. Hopefully you appreciated that and followed it. Sometimes it gets a little wonky in those conversations, and I myself get lost in terms of where we're at, as you could tell when he was trying to lay it out. But nobody does it better than him, and you probably follow some of those conversations better than I do. So thank you very much for listening to today's conversation with Eric Segall. If you want to thank him, I know he'll appreciate it. You know how to do it on social media. And of course, nothing can be better than if you subscribe and download his podcast, Supreme Myth, because I know he would love for you to hear those conversations. All right. Well, that's it. I hope you liked it, and give a rating on Spotify or iTunes if you haven't already. And I'm going to go now because it's on to the next one. StandUpWithPete.com, StandUpWithPete@gmail.com. Talk to you later.
Keep right on ignoring us if it keeps in sight. You got to open up the window to let in some light. You got to stand up. That's right. You got to rise up. You got to stand up. You got to stare the devil straight in the eye. We got to let him know it's his turn to go. See it clear when all you hear is a lie. So get up off of your butt, get down off of your fence. Even if it ain't a very friendly audience, well, they'll begin to listen when you start making sense and you stand up, stand up. No need to point your rifle to defend your town, just stand up, stand up. You know they can't deny you what you're laying down. Boy, you better stand up, stand up. Show your face of every color, yellow, black, red, and brown. She's the place where every lost child will finally be found. There's only one thing to do before we stand our ground, and that's stand up, stand up. Well, the founding fathers saw a land for all. They had to stand up, they had to stand up. They had a keen imagination for a crystal ball, drawing all the plans of a stand up. But all they had to go on was the time they were in, with other causes for laws, and since they weren't even sin, they knew that change was gonna come before the change could begin. They had to stand up. All right, they had to stand up. We got to stand up. We got to look the devil square in the eye. We gotta let him know it's his time to go, and make it clear when all we hear is a lie. Why you lying awake wondering where the money all went? It'll be the cost of freedom that'll go unspent. You can see him flee the scene of that experiment if you stand up. All right, we got to speak up, we got to reach up and raise your voice in every way you know how. Don't be toes up, you got to show up. Ain't no better time to do it but now. No need to pledge allegiance to no wanton tribe. Rise up, show obedience to the voice inside, and listen well and it'll tell you not to run and hide. It says stand up.